Welcome to another episode of The Breakdown. Oh, kids, I'm so excited for the guest that we have today. I have been, no secret, trying to get them on the show for a little bit of time, but they're very, very busy because they are an assistant professor at the Faculty of Law and a member of the John Dosseter Ethics Center. They first came to our attention when they did an unbelievably good TikTok, and we don't even watch TikTok. We try not to TikTok here at the Breakdown because we're too old for it. But very, very excited to welcome to the show lawyer, assistant professor, award-winning person, uh, Florence Ashley. Florence, thank you so much for taking the time to chat with us today.
Thanks for having me.
So yeah, I want to start, if it's okay with you, I want to start with you put out a TikTok video a while ago. It was probably like almost 8 or 9 months ago now. And it was mind-blowingly good because we have this predilection in Alberta for believing in this thing called parental rights or parents' rights. And we have this belief that they are somehow this sacrosanct, uh, parents get the final say over everything because it is their right to do so in the province of Alberta. And you just laid that whole idea to waste. So I want to start with that. When you hear people like the Premier of Alberta, Danielle Smith, saying, "Oh, parental rights, we believe in parental rights here in Alberta," when you hear people talking about parental rights as a justification for, I don't know, horrifying draconian policies that have been announced, what is your take on parental rights?
Yeah, so I mean, the first thing I think about is how misleading that is. Now, in terms of TikTok, first of all, I don't agree that it's for only that we're too old for it. I think we're cool enough. It's fine. Because I use TikTok. And of course, in that TikTok, I don't necessarily go over all of the nuances. It's not. As with everything in law, the answer is rarely yes or no, but sometimes for TikTok, you try to boil it down as much to a yes and no as you can. And I'd say if I have to give a yes or no if parental rights exist in Canada, the answer is going to be mostly no. Of course, there are nuances that are important here, but overall, I think it's more accurate to say that there's no such thing as parental rights. There is such a thing as parental authority or parental powers. And that's an important distinction because if, say, I have, power of attorney for somebody else, I don't usually say that I have a right to do whatever I want with them because really I'm exercising their rights. I just have the power to take actions in their best interests. Whereas prototypically, when we speak of a right, we mean something that you can exercise according to your own interests, sometimes limited by the interests of others, but not fundamentally as a means of furthering the interests of another person. When you have a power to do something that's only really for the interest of another person, that's usually called a fiduciary duty, a fiduciary relationship. And you have powers as a fiduciary, but that's what happens with children and parents, really, because I mean, just imagine how weird it would be if we said that truly parental rights exist, because when the kid is at school, legally speaking, the teacher essentially becomes the guardian of the child on a temporary basis and exercises the powers and authority of the parent within the context of the school. So we would be saying that now the teacher has rights vis-a-vis the child. And that certainly sounds odd to say. And I think a lot of people who support this idea of parental rights would also be like, ooh, that's maybe not somewhere that I'm quite ready to go. Now, um, in Canada, we do have a few decisions that have recognized something that was stated as sort of parental rights, but there's kind of really two really, really huge qualifiers to that. The first one is that when they did so in a way that didn't distinguish between this idea of parental rights versus parental authority. And I think it's much more accurate to say that they were actually about parental authority. And the other part of it is that these rights were not effective in the sense that when that was applied, they were challenging family law, so the custody regime where you have to make every decision in the best interest of the child, and they were challenging child protection and the mechanism for taking the child away from abusive families. And in both cases, they said, well, sure, there's a measure of parental rights at the constitutional level, but these impediments, these impairments to those parental rights slash authority are justified under the Constitution. In one of them, they said first because you don't have any sort of right whatsoever to do anything that would be harmful to your child. So yes, you have a certain amount of power, but that power only exists insofar as you're serving the interest of the child. And even if we're not adopting that legal pathway, in any case, under the Section 1 of the Canadian Constitution of the Charter, it would be justified because the best interest of the child is really paramount here, is much more important than whatever kind of constitutional right parents have to do whatever they please, as distinguished from, say, procedural protections to ensure that the parents can actually put forward their own views about the best interest of the child, given that they're in the child's life, like they have a lot of insight that the government doesn't have. And so, of course, it makes tons of sense that they would have a certain amount of procedural protections as parents. That's very important. And importantly, it's also about protecting the child. You can't adequately protect the child if you're saying that the government gets to do whatever it wants without the parents even getting to have a say in the hearing and without an option to present their views. But once you have that structure set up, you end up in a situation where the entire field is covered more or less by those two legal regimes. Almost everything is covered by the best interest of the child under custody law and by child protection law. Part of it is because child custody legislation applies to all parents, even when they're not separated. Even when parents are together, there are, the family law applies, and in a lot of those family statutes, there is a provision that says all decisions by the parent have to be made in the best interest of the child. And so that means if they're making a decision that's not in the best interest of the child, that's a decision that's outside their jurisdiction as parents. And so, we can say, oh yeah, well, maybe in theory they have that right constitutionally, but in practice, because family law regimes and child protection law regimes are constitutional, have been held constitutional, there's not a lot of room left for parental rights that are anything else than just an exercise of parental power in the best interest of the child, which is how the family law regime is set up. And in fact, in family law, if you look at family law decisions, you'll find Supreme Court decisions that very explicitly say that in family law, we don't talk of parental rights anymore. Not really. We talk about parental duties. Parents have duties towards their child, and they have powers to discharge those duties. Because, of course, when you're a parent, you need a certain amount of power to do your job as a parent. Because otherwise, there's a bunch of things that parents need to do that couldn't be done if there wasn't that authority from just things like bring your kid to the doctor. But still, we're largely thinking in terms of the right of the child, even for things like parenting time, what's known as the right of access sometimes. Well, courts have been pretty clear that that's actually a right of the child, not a right of the parent. The child has a right to, know their parents, to have contacts with their parents. It's not a right of the parent to know their child. Now, does the outcome change that much based on those two conceptions? Well, not that much, because, well, it turns out that relationships are reciprocal, and when it's in the best interest of the child to know their parent, it kind of goes both ways. But it's still a different way of thinking about it. It's a different frame, and it's an important difference because children are people. In Canada, we don't accept the idea that you can have rights over third persons. Uh, that's just not something that we allow. This idea of children as sort of like property or quasi-property of their parents is something that we've fully left behind as we did with other forms of property like coverture for women and also the long and disturbing history of slavery in Canada. And we've said that's just not something that's acceptable at all in a free and democratic society. And so we've moved away from that. And so as a byproduct of that, we have to see children as full persons that are dependent on others to a greater degree than most adults. None of us is fully independent. This idea of perfect independence is a myth, but there's still degrees, and children tend to have a higher degree of dependence than most adults. But that doesn't change the fact that they're persons and must be treated as such, and that's an important part of the law.
You gave me so much to unpack there. Wow. So i- I want to pull a couple of things out of there because I think there's some really important pieces. Given everything that you said there, would it be fair to say to sum up and some of the pieces there that the primary role of the parent is to be the caretaker of the children's rights, but those rights still absolutely belong to the kids. Is that a safe statement?
Absolutely. Parents are caretakers. They're there to take care of the children. They're, in more legalese term, they're fiduciaries of their child. And, as much as they need a certain level of power to do so, because otherwise they couldn't even, like, say, open a bank account for their kid. Uh, it remains a fact that the child is the one who has rights in that relationship. Now, of course, parents have rights as persons. That's different from having rights as parents, right? And that's an important distinction. And sometimes I do think that some people who are claiming parental rights are conflating the two. So there's a conflation between power and rights, but there's also a conflation between uh, the rights that parents have by virtue of being persons and the rights that parents have by virtue of being parents, which I think have important differences there.
One of the things that I want to really explore a little bit is in that opening statement that you gave there. One of the things that was reoccurring was the parents have the fiduciary duty or the responsibility to exercise and protect the rights of their children. In the best interest of the child. And this is another place where I think things have gotten weird because what defines, from a legal standpoint, what defines the best interest of the child? Because there are some people who say, it is in the best interest of my child for them to absolutely not learn anything about anything sex ed related from anybody other than me. And I don't want to talk about it. And that's the best interest of my child because there, I said so. There are other people who make the argument that, well, with STI rates skyrocketing and teen pregnancy rates associated with uh, less access to things like sex ed, that it demonstrably in the best interest of the child to have that information presented to them in a responsible, professional, manner. So, how do we know what the best interest of the child is when there's so many competing views?
It's certainly a complicated thing, and there's in many ways the best interest of the child, and I teach that in my children in the law class, and it's always an issue, but again, is that for the most part, the best interest of the child is the best interest of the child is the best interest of the child. There's a bit of a circular notion there, and people don't fully agree what that best interest is. Now, generally speaking, there is a sense that it includes, a psychological, social, and physical well-being. You want a child who's mentally healthy. You want a child who has good relationship with others, or at least who is given the tools to have good relationships with others as much as possible. And you want a child who is physically healthy, but you also want a child who's going to be able to like grow up and be a full participant in civil society, and really be able to kind of like flourish in their own personal, in unique ways and skills. Uh, and here there's an important thing where like parents get to share their values with their kids, but once they start imposing them, that becomes an issue. Now you're starting to cross a line when you start imposing visions of the good life. Children should be fostered into figuring out what kind of life they find valuable, what kind of life they want to lead. And of course, if you have a kid who's very young, who's like, I just want to sit at home and eat candy all the time, we're not talking about that. We're talking about this more kind of longitudinal perspective where we want to create adults who get to decide what kind of life they think is valuable, is significant. And the problem arises when parents are starting to really impose their values in ways that says like, no, you can't be gay, you can't be trans, you can't be you can't be a woman and work. You have to fulfill this particular social or religious role. That's when we run into issues where we kind of like butt against the best interest of the child. And an important thing to understand and recognize first is that there is this notion of the child's right to an open future. It's part of the equation. The idea of like not precluding, not too readily precluding certain types of potential futures, for instance, by depriving children of education that they're not, that are going to, harm them so much they're not really going to be able to like say get further education later down the road because they don't have that basic education. Now, it's not an absolute right. It's just really one factor in the equation, but that's one thing that we may be wanting to think about. Another thing that's really important is that children's views are part of their best interest, and that's a really, really critical thing that's recognized in Canadian law and that we've adopted from the Convention on the Rights of the Child. So in the Convention on the Rights of the Child, in Article 10, we have this idea of like, once a child is capable of forming their own views, then not only do they have a right to express their views in all matters that impact them, but their views should be given due weight according to their age and maturity. And in the kind of Canadian family law context, that creates a spectrum of maturity where once a child is mature enough, is considered a mature minor. Once you reach that threshold, your views are effectively determinative. Once you're a mature minor, once you reach that threshold of capacity, which some studies have suggested arises as early as like 11, 12, of course, with appropriate supports in place for decision making, because one of the things we know about children is that one of the big problems of adolescence is impulsivity and not ability to make decisions. So it's not that they don't understand, their ability to make decisions, not that they don't have the cognitive capacity to make decisions, is that when they're in a context of pressure, what we call a hot context, as opposed to cold context, they tend to make, not great decisions that are really kind of impulsive and don't necessarily think through the issues, and they tend to let themselves kind of get pressured. The matter is very different once they're in what we call the cold context, where it's a calm context, where you get to have conversations, you get to sit down, slow down, and think and talk about things. Then we know that those decisions tend to be, in fact, quite, reflect quite a high degree of maturity and intelligence. And so what we want to do with that is push youth towards a cold context whenever they have to make a decision and try to, avoid having them make decisions when they are in that hot context, when they are in that, emergency or urgent context, or, in the playground with their dumb friends who are trying to peer pressure them into doing something, not very smart. And by the way, let's face it, adults succumb to peer pressure a ton. In fact, we have some studies that suggest that they may, some might say they are actually even more prone to peer pressure, and that the big difference is that we have much more decentralized spheres, social spheres, which leads to a lot more reality checking. And so it's a lot kind of harder to be so disconnected from the mainstream that you make, like peer pressure decisions are completely off the mark. But one, it still happens. And two, as our world continues to like be divided more and more into information bubbles, we'll actually start seeing that more and more. These very same dynamics of peer pressure that we're seeing in youth are likely to start being seen a lot more and more with adults. And I mean, I would argue we're already seeing it pretty clearly in notably the United States, the Trumpist electorate. So, there's a lot of assumptions about the difference between adult and youth cognition that is not necessarily well thought out. And I think some people misunderstand why we place some restrictions on youth. Like for instance, we want them to make cold decisions, not hot decisions. That's a reason to put some level of perhaps a safeguarding in terms of their decision. But that's different from saying that they can't make smart, cold situation decisions on our own. Now, in Canada, as I said, when you're considered sufficiently mature, and some studies say can arise as early as like, 11, 12, and of course, it's going to vary by context, because it's not a one size fits all determination. You can be a mature minor for one purpose and not the other. But once you're considered a mature minor, you have more or less the medical and just personal autonomy of an adult within the context of medical decision making in the family. And then it's a spectrum, right? The younger you are, the less your views matter. And when you're somewhere in between, then the degree of your maturity should determine the degree of weight that your views are given. And I think the corollary of that is when you're making less influential decisions, then you should generally be afforded a greater leeway, even if you have less maturity, because yes, your views have less weight, but so is any risk that you're staving off, and so it kind of still balances out. Now, that's the theory. The reality is a lot more complicated because the reality of it is that there's still no enforcement mechanism for that other than the court or child protection agencies. Now, child protection agencies aren't checking if you're making decisions in the best interest of the child. They're checking if you're essentially fucking up your child. And they do apply that logic very discriminatorily, especially for Indigenous families. But the flip side is also that, like, if they're faced with, say, a more kind of like middle-class white family, they give them a hell of a lot more leeway before they start intervening. But also, a lot of kids weren't. You don't want to call the CPS on your parents unless it's like really, really, really bad, right? It's not just a matter like you just having your best interest disrespected is not necessarily enough given just how bad it is to be in the welfare system. So that leaves you with the family law structure. And well, in a family law structure, you can go to court, but if you're a kid, what you gonna do? You're gonna go find a lawyer and sue your parents, like realistically. And so we end up with a situation where, like, on the ground, parents get to make more or less any decision that they want in practice, not because they have the right to do so, but because there's nobody really to stop them, and their kids are dependent upon them financially and for housing, for so many things, that as a result, the actual law goes unenforced. And I think that's partly why parents think they have so much more rights and power than they actually do. It's because nobody's coming knocking at your door to check if you actually make all your decisions in the best interest of the child. There's no enforcement mechanism other than going to court, and people aren't going to go to court unless things get really, really bad.
I want to play with something in as respectfully a way as I can. Uh, but there's a piece that you mentioned earlier that really kind of resonated with me, and that's the idea that a parent's values. A parents can say, "I would like you to be a good housewife. That's what I want you to be." Um, that is a different thing than saying you have to be a good housewife. I will find this person that you will marry, and you will be their very good housewife, and that's it. You don't get any say in it. That's the
Yeah.
deal. That is a very different thing to me, he said cautiously, than some of the other examples that you used, which I would argue are matters of identity as opposed to, let's go with occupation. So I think there's a big difference between a parent being able to say, I want you to be a housewife, you will be a housewife, and a parent saying, I want you to be straight, you will be straight. Those are two, I mean, there's a values component to both for sure, but I think that the evidence supports that when you're talking about gender or sex or orientation or there's actual medical organic evidence that says this is more than just this is how I feel as a parent. There's real things that are going on here. How does that Here's the question that I'm trying to ask. It seems like one of the big disconnects is that and it's the unspoken part, is that parents go, well, I don't want you to be gay. Um, and the subtext of that seems to be twofold. A, being gay is bad, wrong, whatever. And B, it's a choice. And those two things aren't true, to my understanding, he said, is the middle-aged, straight, cis-presenting white guy. But how does the legal system delineate between parental values of those things and like gender dysphoria is real? It is a diagnosable medical condition that has medical treatments. That's not you can have all the feelings that you want about it, but that doesn't make it any less real. How does the legal system approach these things?
Yes, I mean the answer is case by case, right? There's no kind of like list of categories of things you get to pick versus not. And I mean even in queer and trans circles, you're gonna have a lot of different views about what these things are. Like I tend to I've been fairly well known to kind of be pushed back a lot on the idea of like, trans as gender dysphoria because I'm like, well, I mean, yeah, sure, there's gender dysphoria, but also like we don't name dysphoria for most of the shit that makes us sad in life. And if anybody gets like gender swapped in a Freaky Friday situation, they're probably gonna be pretty distressed. And it feels weird to say that that's like quote unquote a medical issue, especially a sort of like mental health issue, when it feels like the gender swap was the issue. And so, and there's kind of, and so I guess there's kind of like this relational aspect that I usually emphasize more in terms of like, it's about your relationship to your gender in society and to your gender in and to your body as something that has like, a certain gendered connotation. Now, um, we also don't think about that way for like being gay a lot of the time anymore, which is an interesting thing. Now, at the same time, that doesn't mean you can change them, right? Even if you're like a social constructionist about gender, which I am, I've argued that gender identity is largely a sort of like a socially constructed thing, or at least gender is socially constructed, and thus our psychological identification with it bears some of that social constructiveness to it, and that it's constructed in a manner that most parts of our psychological identity are. That in many ways it's a very important but also psychologically mundane phenomenon. Um, that doesn't mean you can change it, right? Um, because the direction a car is going is changeable. It's not a fixed thing. You're not on a railroad track. And yet, if I take my pickup and ram into somebody to make them change direction, that's still not a good idea, right? And so the fact that something is dynamic or fluid or socially constructed does not mean you can change it in any sort of like willed manner. Um, and that's kind of an important thing, especially for my work on conversion therapy. Um, Now, another thing is I think like the degree of personal aspects to it are very critical here. Um, for most stuff, our values tend to be fairly well shared. It's not perfect, but there's broad levels of agreement. We don't want to be sick. We don't want to, be puking all the time. We don't, there's a fairly shared sense of things. Certain things are good and certain things are bad in life. And, there's broad sense of that. And sometimes it's also certain things are good and bad for certain groups because of how society, social relationships work. Like, for instance, um, you know, being stopped by the police is a lot worse if you're a young black man than if you're uh, feminine law, tall white law professor. Um, but identity, when it comes to like, gender identity and sexuality, is that it's a very personal identity. It's not a social identity in the way that even, say, religion is. Now, you know, everything religion is not a perfectly social identity. There are individual aspects to it, but it is still usually, oftentimes, and especially for non-Christian religions, tends to have a very significant collective component to it in a way that like is not the case for gender identity or sexual orientation. That tends to be just so much more personal, that anybody else's identity around you has really no impact on how you feel about it. And so it gives them an extremely limited perspective on whether you want to be, you want to transition, you want to live out, your life as a openly queer person and things like that. And so there is really, I do think there is a significant difference. Now, the thing is, on the other side, they'll say, well, yeah, but being gay is just bad for everybody because our religion says so. And then I'd say, does it actually? But that's besides the point. We're not going to enter into a debate on Leviticus. Was it like 1829, something like that? Whatever. We can go into the subject of another podcast. But I do think one thing we can perhaps get people to feel a little bit more sympathetic on, or at least like get people understanding a little bit better, is if we turn to the question of religion, as a matter of fact. Imagine if a child just has a deep religious conviction. Given this is Alberta, let's assume, Christian Protestant type belief. And the child's parents are staunch atheists that just really aggressively refuse to let the child say prayers before bed, go to church, express any form of belief whatsoever, and just really, ban. And the child is banned from having a Bible. The child is banned from having anything that's remotely religious. I feel like most people would think like that's pretty shitty. Even if we don't agree with the child's choice for XYZ reason, like there's some people that are staunch atheists and even anti-theists. I don't count myself among that, but but I'm also somebody who doesn't feel personally spoken to by Christianity. So, there are some people that are going to be like, well, that child's still making that decision. But importantly, it still should be their decision. Should be that child's decision, and it's not appropriate for the atheist parents to just like really aggressively impose their own values there. So yes, we can say that sexuality and gender identity is different, and I do think that there's an important manner in which it is a lot more individual in a way that uh, makes it even less appropriate for parents to impose. But I think even for things like religion, we also see, once we start asking ourselves, that it also seems quite inappropriate for the parent to do that imposition. And in fact, examples that we have in the case law have often been religious matters. In Young v. Young, which was the case that essentially ruled that family law was constitutional, that custody was constitutional, it was a case that involved a father who was a Jehovah's Witness, which by itself not at all a problem, except that he was kind of an asshole about it, and would constantly, say that the mother was going to go to hell, would, try to force the kids to go to services, knock on doors over their objections. The kids like really didn't wanna. And so eventually the courts were like, okay, like it went to court and the courts were like, yeah, okay, maybe, like be allowed to share your religion, talk about your religion with your kid, fine. But like you can't start, like forcing them to do stuff when it's not their religion. They have a right to freedom of religion too. They have a right to decide that. And similarly, I think there's a right to there's a paperback, was it Clara Rowland, that talks about the right to live with integrity in relation to gender. And I talk about the right to gender self-determination. We have a right to determine what kind of gendered life we want to live. It's such a huge aspect of our society that to live a life in a different gender is to lead a radically different life. And it's something that only really the person gets to really know if it suits them. And so, it's fine for parents to share the values, especially if it's not in a way that is harmful to the child. When the way of sharing their values becomes harmful to the child, that's another question. Um, but that's still different from imposing. And that's where I think that's something that I think is generally speaking quite inappropriate. Like at the foundation of liberal democracy is this idea that everybody gets to pursue their own vision of the good life. As much as it wasn't adopted constitutionally, and as much as I have mixed feelings about the US, life, liberty, and the pursuit of happiness, right, is, I think, a pretty good slogan. And, so making those kind of core fundamental decisions about yourself, deciding what kind of life you want to lead, is really important. Now, we can have discussion when that choice is fundamentally harmful, right? Like, kid just wants to become a Nazi, we're gonna have to do something about that. But that's already a different question, because at that point, we're not even really talking about the best interest of the child. We're talking about the best interest of like literally every other child, right?
You're not wrong. Um, and I want to clarify. I did not mean to suggest that the areas of sexuality, gender are binary states. The
Oh yeah, yeah,
things that influence them are, it's that whole nature nurture. Where does the Venn diagram overlap? And I think it overlaps differently for every single person. So there's no easy answer. But I want to go a little bit more. Is there a hierarchy of rights? So there seems to be a perception that if somebody has the right to be provided with the necessities of life, let's say, that seems like it's a really, really big right that should kind of override all of the other ones to some degree. At the same time, though, um, I've never seen, and maybe I just haven't read enough books on it, but I've never seen like this is the order of rights, and these ones win, these ones don't. This one's more important. Sometimes this one moves around a little bit. Like, is that a thing, or is it very much individual, very much predicated on each individual situation and in person?
Yeah, so we absolutely do not have like recognized hierarchies of rights. What we have are individual situations, but also underlying principles that help us ascertain what is the line between certain rights. Generally speaking, for instance, freedom of whatever, freedom of religion, freedom of speech, whatever, doesn't extend to removing the rights of others to do that, right? Like, I don't have the freedom of expression to put my words in the mouth of somebody else. Um, that is not part of my freedom of expression. Similarly, my freedom of religion, even if my religious belief is that I should force convert everybody, I don't get to do that because that's not what freedom of religion is about. Freedom of religion is about me being at liberty to practice my own religion within the bounds of respect for others. But the moment I'm overstepping onto others' own, ability to just live their life however they want, uh, my freedom stops. And of course, when that line exactly arrives can be fuzzy. But still, generally speaking, there are these sort of like internal logics to it. So that's one of the internal logic. Another is that, well, freedom of expression isn't as valuable for all types of speech. You can regulate professional speech a lot easier than personal political speech because personal political speech is really at the heart of democratic governance in a way that speech as a doctor isn't, right? Speech as a doctor, by becoming a doctor, you're giving up, your right to act against professional competence regulations. You're expected to act, in certain ways, and the protection of patients is ensured by sometimes regulating that speech. And so it's going to vary quite a lot. And similarly, hate speech, not not really high on the not really high in the hierarchy there. You know, even in the US where free speech, where hate speech is free speech, they're still not going so far as to claim that hate speech is like the pinnacle of the best speech ever. Um, and so, same logic in Canada. In fact, some forms of speech, like hate speech, are considered so vile that they don't even get constitutional protections. Um, of course, hate speech is a complicated concept because different, there's different views as what counts as hate speech. There's criminal hate speech, there's civil hate speech. In some provinces, it gets complicated. But still, generally speaking, there's an understanding that when you're hating on groups of people and dehumanizing people, that's really low in terms of like the value of that speech. And so even though there's no necessarily hierarchy of rights, the internal logic of different rights and why we even have those rights in the first place, like what are they about, is an important part of the calculus. I teach criminal law, so we often talk about that. What is the right to against search and seizure about? Well, it's the right to be left the fuck alone. The right to privacy in your own personal life so that you can govern your own life without constantly being, like having people know your shit. And that's seen as intertwined with dignity. Similarly, right not to be detained, right to be left the fuck alone. I don't want to be detained by the cops all the time, and and that's also intertwined with search and seizure because they have to do the search. And when you're getting patted down and they're touching your junk, that's not necessarily the best of times. I mean, maybe I don't know. Some people might be some people's king, but generally speaking.
So, and I want to just take a sec to go back to the colleges thing because you touched on that, and that's a big contentious issue. I would make the argument, and please correct me if I'm wrong, but I would make the argument that when we're talking about colleges, we're talking about people who have earned protected titles. I can't just run around calling myself a doctor of medicine because I wanna. If I use those terms, there's a recognition in our society that certain titles bestow a certain degree of credibility. And so if you start saying things that damages the credibility of those titles, then you need to be held to account. So if you're running around saying, I used this in a previous interview, if it, I work professionally as a paramedic, if I start running around saying somebody's having a heart attack, give them Basil. Somebody's having strokes, give them Basil. Somebody's arm gets cut off, just rub a little Basil on it. That would be, don't do any of that. That would be irresponsible of me, and it would reflect poorly on the credibility that the title of paramedic affords me in the sphere of emergency medicine, and it should only be emergency medicine, no other areas, for the record.
Mhm.
Um, but so I think that that's another space where, yeah, I'm very mindful on the show when we talk about healthcare, where we talk about EMS issues. I'm like, okay, so I'm going to take off this hat and I'm going to put on my other hat because I can't speak about certain things using the title. It would be very irresponsible of me to speak about certain things, trying to give myself additional unearned, undeserved credibility by saying, yes, but I'm a paramedic, so you should listen to me. So there's my little rant about colleges. But am I wrong on that?
Uh, no, you're pretty right. And I think one of the ways in which we usually conceive it is not even yes, there's the reputational aspect, and that's an important thing to kind of preserve, but also just the fact that like once you're a member of a profession, you're given a certain amount of power and privileges that others don't, and that there's a trade-off. And the trade-off is that you got to do, you got to submit to a certain set of rules that primarily exist for the protection of the public. Not only there's various types of rules for different various types of reasons, but the primary purpose of those rules is the protection of the public. Uh, it's actually quite interesting. Yeah, there are protected titles, right? I don't actually know what the situation is in let's see, Doctor blah blah blah. Okay, so because in Quebec, I would actually not be able to call myself a doctor, even though I have a doctorate, because doctor are is a title that's reserved for only specific doctorates. And in fact, it's defined in a way that's like super complicated to track out, but generally it means medical doctor, uh, I think dentist, vet, and psychologist, um, and a doctor of law with specialization in bioethics would not count. Um, there's other places in the world where I can call myself a doctor. I don't anyway. And I think looking very quickly, it seems that I probably could in Alberta in most
Oh, you 100%
contexts.
could. You 100%
Uh,
could. 'Cause my dad has a PhD in paleoentomology, and you refer to this is one of the reasons why, if I'm aware of the fact that somebody has a PhD, I refer to them as doctor, because that's how I was raised to respect those titles. But it's an interesting point you bring up, because I actually was trying to look at how to translate doctor, like with a PhD, into French, and the only online interpretations that I could find all interpreted it to like medicine, and I was like, oh, but I can't do that because that's not. This
yeah.
gets complicated. So
Which
yeah,
is kind of funny because I mean the real doctorate is the PhD because doctor means teacher. It's a license to teach, and it was stolen later on by the medical doctors. How rude! And then eventually, also, I mean, law started adopting JDs uh, as their basic qualification. But is a whole other thing. But yeah, and I actually tell my students, please don't call me doctor. It sounds pretentious. But I'm not the most formal person in general. But yeah, like you don't get to do whatever you want. And in fact, right, like I mean, think about it. If we were free speech absolutists, a prescription is words on a paper. Does that mean you get to prescribe like fentanyl to anybody who comes through your door just because they want it? Like,
yeah. Here's the argument that I've been building for the last hour or so, give or take. Um, if we are to say that youth, kids, whatever, they all have their own rights, and parents are the custodians or the guardians or the administrators of those rights until that person develops the capacity to be able to do so on their own without grown-up supervision. Some days I don't even meet that bar. Um, if we start from there, and if we say that there are no hierarchies of rights, um, my next question has to be, at what point is it acceptable? For the record, I don't think it is. But at what point is it acceptable for governments to say, hey, I think that this thing that I'm defining in a right that may or may not technically appear in the charter overrides all of your other rights. So, of course, now I'm getting into the Danielle Smith UCP anti-trans policies. The
Yeah.
justification has been we're protecting their right to reproduce, which is an incredibly fraught argument for a whole list of reasons. But if we just take it at face value, what do you make of the government saying we're going to impinge or prohibit the agency of these people, these people who are figuring out who they are, um, under the supervision of their parents, no less. And we're just going to say everybody's wrong except for us because I got 5,000 votes at an AGM. I win. Haha. What do you make of all that?
Yeah, I mean, in a constitutional democracy, how it works is the government gets to say and do whatever the fuck it wants, and then we get to show up to court and take them to task. They are allowed to override statutory rights. So if there are rights that only exist by virtue of statutes, they can override those whenever they want. Uh, they cannot do that as easily for constitutional rights unless they invoke the notwithstanding clause. So absent the notwithstanding clause, then they can pass any law that they want, but they cannot violate these constitutional rights, specifically charter rights. Although there's another aspect of that, which is that there's other parts of the Constitution. The Constitution is not only the charter. There's also things like the division of power. When provinces were trying to kind of like indirectly ban abortion after the federal decriminalization through Morgentaler, the Supreme Court said, no, you're trying to pass criminal laws, and that's a federal power. And you don't get to do that. Only the federal government gets to pass criminal laws. But yeah, I mean, they gotta make a showing for it and try to argue that it is in fact respecting the rights of the people involved, the children. And one thing that they're gonna have to try to get over is a precedent called AC versus Manitoba, which is the mature minor precedent that says that in essence, children who are mature minor get to make those decisions for themselves. Those quote unquote adult decisions, because in terms of maturity, they're very much as adults, and so they get to make those decisions if adults are able to make those decisions. Now, of course, doesn't mean you get a right to vote and stuff like that. That's a different matter. But when it comes to like, say, medical decisions, these like very fundamental decisions, that are comparable to things like abortion, then the government has to show how they're not violating those rights. Well, in fact, it's more the other side that has to show how they're violating those rights, but the government is not exactly on great scientific footing, so they're primarily going to be the one on the back foot in this particular case. Yeah, and so that's how you fight it out.
I guess the question that I'm trying to understand is if the determiner of the identity rights is the child, and if the parent is the guardian or executor or whatever you want to call it of those rights, to really screw up some legal terminology, I'm sure. And they're both on the same page and they're looking to access evidence-based care. And the government's argument is, we're not going to let you do that, even though you are the two most qualified groups, the kid and the parent. to determine how these rights are exercised. We're just not going to let you do that because we believe that being able to reproduce down the road trumps everything. Um, that to me is unless I'm mistaken, that's a pretty novel or new argument for the revocation of the exercising of those rights. Is there a precedent for the government to say, no, no, you have to have your fertility at all costs, um, that is upheld? Like to me, it is a slippery slope from this, and I'm going to be hyperbolic, so slippery slope probably isn't the right way. But for me, it's not a huge leap. If we're going to say that the ability to reproduce is the most important thing about a person's identity, then we have a lot of coma patients that we're going to need to be keeping alive. And I don't mean to be crass, but that's where I keep getting back to. How wrong am I on that?
Yeah, I wouldn't say wrong. I mean, look, at the end of the day, what they're going to be trying to show is that all those people are, in fact, provably wrong, right? Like they can't just go to court and argue that their opinions don't matter, that the best interest of the child doesn't matter. The only thing that matters is fertility, which is should be the sole and only determinant of the best interest of the child. Well, they're gonna have to show that people are wrong. So either they're gonna have to show that um, you know it is in fact true that the only thing that really matters is the fertility of the child, which I mean is such a bonkers argument. I don't think they're actually going to be trying that. Rather, they're probably going to say it's not sufficiently scientifically proven to overcome the various downsides, which include fertility, which include the chance of regret, which include blah 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 blah. And so what they're going to be throwing is not so much that fertility is the only thing that matters, but rather that it outweighs these other factors. But it is certainly a huge uphill battle because, well, the, the science is not really on their side. Like at the end of the day, the best argument they've got is that the evidence base is not strong enough to support. But that doesn't change the fact that like we have a mountain of evidence that still all supports the idea that there's a very strong positive benefit to gender affirming care and very little evidence showing harm, and that evidence showing harm is even weaker than the evidence showing the benefits. And so it applies both ways, right? Like you can't get both. Like it's either too low to be reliable or it's not. And if the evidence of the idea like it's harmful for some people and things like that, well, those have the same, if and worse pitfalls, in fact, than data showing consistently benefits. And that's also an important thing to kind of like note here is that this isn't a situation where we have, only observational studies, which now that is in fact mostly the only thing we have, but it's not a situation where we only have observational studies and some of them show a positive benefit, some of them showed negative outcomes, and it's kind of like a little bit on both sides, and then people are cherry picking the ones that are showing benefits. Everything we have shows benefits. The studies that they claim don't show benefits are studies that just don't show statistically significant benefits. But if you look at the data, a lot of the time they're like literally on the edge of being statistically significant. Like literally, like I've seen studies where they're like, this result was not significant, which shows that that gender affirming care is wrong. And the study is like P equals 0.05. And technically you need it to be anything like marginally below it, And you're like, come on, come on, or it'll be like 0.051 and another nonsense like that. And you're like, it would be very different if like we had things on that were like there was a genuine like some things showed positive results, some things showed negative results, and then we had to like figure it out between that. But everything is positive, or maybe some of them are neutral, right? Especially when it comes to like puberty blockers, we do have some studies showing a more kind of neutral effect, or a much smaller positive effect, which makes a lot of sense because they're meant to prevent certain developments. They're not meant to uh, change the child's body. They're meant to prevent changes, and so even though there are usually still going to be some like um, a certain degree of like mental health benefits because of the relief of not having to go through the puberty, it's still going to be a lot less than actually getting to go through the puberty that you want. And in fact, we would expect that perhaps there might even be some slight negative impact because you're being denied the ability to go through puberty at the same age as your peers. Because puberty blockers, at the end of the day, are a compromise. They're not what trans kids want. They want hormones. They're being put on puberty blockers because there's a level of like kind of like risk aversion, and they're like, oh, but we want to be sure, despite the fact that statistically speaking, we know that like the kids who go on puberty blockers don't like end up going on hormones. Like it's extremely rare for them not to do so, and it's extremely rare for them to regret. So you're like, why are we going through that charade of that compromised position? But that's what we're kind of like stuck with. Um, what I'm very worried about though is what they'll get to ban if this passes, if this goes through the courts and the courts are okay with it, because like there's a lot of stuff that has a lot worse evidence based than gender affirming care that we use all the time. I mean, I remember when I arrived at in Edmonton, I had a meeting with the director of the John Dossiter Center of Health Ethics Centers, and he's a bioethicist, but he's a doctor at NICU, Newborn Intensive Care Unit. Um, and he was like, yeah, if we need the level of evidence they're expecting of trans care in NICU, like we can't do anything anymore. Like none of our treatments reach that level because we can't run studies on newborns, you know? And similarly in trans care, we can't really get what they want, which are long-term randomized control trials. Because first of all, when they're long-term, they complain that they're too old. And well, yeah, that's how longitudinal trials work. If you want something you're only gonna get it after a while. That's how things work. So they're like, oh well, it started like long before the current wave of trans people. I'm like, yeah, but that's how long-term studies work. Like that's always gonna be the case. Um, and then the other aspect is like they want randomized control trials. We can't do randomized control trials because the moment that trans people figure out they're in the control branch, they're gonna leave the fuck out of your study and they're gonna go get their hormones somewhere else. In fact, a lot of them are gonna go get their hormones somewhere else anyway. They'll just get it from the gray market. Um, so like this is not it's not working. In fact, we know that because they tried to do it for a study on puberty blockers for central precocious puberty. They tried to do a randomized controlled trial, and let's think about it. Like central precocious puberty, the degree to which these kids want the puberty blockers is a lot lesser than trans kids. And despite that, the entire control arm left when they realized they were in the control arm and they weren't in the arm that was getting the actual puberty blockers. And so it was transformed into an observational study because you in fact can't do a randomized control trial. It's just not feasible in for that kind of stuff. And that's pretty common when you have highly desired interventions that um, uh, highly desired interventions that have like physiologically obvious uh, effects, you can't really do a randomized control trial. You need to be when they want something really bad, then it needs to be masked. If it unmasks, it stops working. And even then, there's still issues, even if you're able to mask. But we don't even need to turn there because they can't. We know what hormones do. In fact, if you can't tell whether the hormones are working, then we wouldn't expect any sort of psychological benefit because the changes are the causal factor of the benefit. I mean, the main benefit is actually like having the change to your body you want, but any measurable mental health impact is going to come as a byproduct of actually having the changes. So, they're expecting just ridiculous expectations. And it's also dangerous because abortion. So there were debates around mental health and abortion in the 2000s and 2010s. And there were a few reports that came out by, American Psychiatric Association, Royal Colleges in the UK. And they looked at the evidence and were like, yes, there is in fact a measured correlation between abortion and lower mental health, but the evidence is low quality, and and that's expected, right? Like, if you need an abortion, it's not exactly like it's oftentimes not a walk in the park. Like, it's still not like a great time. Just because it's a lot better to have access, and it would be better than if they, were forced to have a child. Um, and of course, you can't study that because you can't, force some people to have a child and not, you can't do a randomized control trial of mental health of access to abortion. That's impossible. Um, and so naturally, we do notice some negative correlation because, yeah, I mean, there's a lot of stigma. There's a lot. Um, but the medical associations all looked at that and were like, well, yeah, but like we don't have any evidence of causation. The evidence quality is simply not high enough to override the right to an abortion as a human right. And I mean, that seems clear to me how we should be approaching gender affirming care, right? Like when you have something that's so personal and intimate and so integral to your identity, then the question is, do you have sufficient evidence of harm to override the right to gender self-determination? The question is not and should not be, are you this tall? Like this tall to ride, but except of this tall to ride is do you have exactly the right kind of studies that we want to prove to us that there is a certain level of mental health benefits? Like that's the wrong approach. Science should be, I say we should have a human rights first approach, science second. It's not that science doesn't matter, it's that our default position, because of human rights, should be access to gender affirming care, access to everything you need for gender self-determination, including, choice of pronouns, choice of name. And then, if people prove that those things are harmful, then we can go back to the drawing board and have that discussion. But I mean, they're not gonna.
I mean, looking at everything that you've said there and looking at the arguments, it seems to me, uh, legal scholar that I'm not, that the arguments that the government could bring forth would be at best very, very weak. Um, and even if they do make the argument that, well, the right to reproductivity is the most important right, um, there's no support for getting rid of puberty blockers based on that because the puberty blockers don't in any way affect fertility. So one would think that that would have to be stricken out. Um, the the reality is in Canada, you can't get bottom surgery until you're over 18 anyways. So moot point. So there's a bunch of different ways to rip it apart. But the piece that I find most chilling perhaps is the notwithstanding clause piece, because there's a lot of people who still don't understand what the notwithstanding clause is. And
Yeah, we've seen that this week.
yeah, and it's literally like, correct me if I'm wrong, but my understanding of the notwithstanding clause is it's basically when a province says, hey, yeah, you've got the charter rights, great document, love it to bits. This part, though, we're just going to say to hell with it. And for a period of 5 years, we're just going to say that, yes, you have that charter right, but notwithstanding that charter right, we're still going to take away your right to any of the human rights.
Yeah,
Um,
I mean, it's a carte blanche to violate human rights. And yeah, I mean, they it's not their only tool in their tool set because if you can't dazzle judges with your brilliance, baffle them with your bullshit. And if they manage to confuse the judges enough, judges don't know shit about science. And so, there's always a possibility that you'll be able to confuse them. That said, that angle hasn't worked terribly well in the United States for the most part. You know, losses at in court have, for the most part, not actually been predicated on the government showing that they like convincing the courts of their own view on the science. Uh, there's been a few kind of judges that were a little bit less sympathetic, mostly very Trump-brained ones. Um, but for the most part, like even the most Trump-brained judges didn't go there. They instead just said, well, you don't have a right, um, as a trans person. It's quite simple. There's no right to abortion. There's no right to be trans either. And discrimination against trans people is perfectly legal. That was their argument. Their argument was that there was just no constitutional right there. It wasn't that the science was on the side of the government, by and large. Um, you know, and so it's not looking good for government in that way. They'll try to say, oh, but the cast review, blah blah blah, and of course, anybody who knows anything knows just how bullshit the cast review is. But perhaps they'll be able to confuse a judge about that, although it's not looking good when you have all of the like Canadian medical associations, uh, citing against the law. Uh, but then we come to the notwithstanding clause, which is like this silver bullet. You get to do whatever you want in terms of violating charter rights. Um, it applies to specific rights, but it applies to all of the rights that we really care about here, which are the right to life, liberty, and security of the person, the right to equality, the right to be protected against cruel and unusual punishment. It also applies to all of the freedoms, right? So like freedom of belief, freedom of religion, freedom of blah blah blah. So yeah, it's a pretty daunting problem and shows really this huge hole within the Canadian constitutional sphere. And I often hear, in fact, the idea of like, why do we have it? And I agree that we shouldn't have it. However, I think people are being a little bit narrow-minded when they say they can't imagine a single time where it would be legitimate to use. Because I've seen U.S. Supreme Court decisions, and there are many of them that I would love to just like say fuck that, right? Things like Citizens United, things like saying, all of these things that essentially attack voter rights under the pretext of billionaires' freedom of expression and shit like that. We've been lucky in Canada. We haven't had as much of these kind of like bonkers constitutional cases that were just really completely, ridiculous. But we didn't know that ahead of time, right? When we got the charter, we didn't know how it would go, and we're lucky that it went in a much better direction. It's not perfect by any stretch of imagination, but frankly, pretty good as far as as far as top courts go, like most places in the world, like we're doing fairly well for ourselves in terms of like how our constitutional and human rights law goes, except for the notwithstanding clause. And there was an expectation. I think there was a dual expectation. The first was that the political price was high enough that people wouldn't use it other than in the most extreme scenarios, um, which worked well when our politics were remotely sane. Um, doesn't work in a world where nobody cares anymore and where fascism is just the way of the land. Um, and then the other aspect is that um, deliberately, and that was the trade-off, in fact, the trade-off that was offered, Pierre Trudeau said, um, if you'll allow us to like not have a notwithstanding clause, we'll remove disallowance as a power. We'll remove the federal power to just nope provincial laws. Because, yeah, the federal government can just say no to provincial laws. Um, it's a power that doesn't get used because, I mean, it's political kryptonite, but so was the notwithstanding clause supposed to be. Um, and so, now we're stuck with that. Now we're stuck with that issue. Now, that said, the notwithstanding clause is not limitless, and we're people I think are really direly misunderstanding it this way because I've seen so many people say that like, oh, you can use the notwithstanding clause to just ignore federal legislation. No, you cannot. That is, in fact, the one of the main things you absolutely cannot do with the notwithstanding clause. The notwithstanding clause has absolutely nothing to do with the division of power. The notwithstanding clause applies to human rights. The federal government doesn't have the human right to have their laws respected. That's not how it works. They have a constitution. There's a constitutional division of power, and the constitutional division of power says if you're the province, you have to obey federal law, and if you pass laws that conflict with federal law, sucks to be you. The federal law is the one that's going to apply. It's called the federal paramountcy doctrine. So that's one thing that they don't understand. And it's one thing that's also relevant to the trans issue because when it comes to the health law, it certainly looks a lot like a criminal law. It certainly looks a lot like a criminal law. And if it's a criminal law, then they don't get to do that. That's what some provinces had tried to say. They said, oh, we're just regulating abortion, we're not banning it. And the Supreme Court was like, yeah, no, we're not falling for that. Like, you're obviously just, you're bullshitting us and we're not entertaining this. And so, that's also part of the thing. There's stuff that can be done about the notwithstanding clause being used for some of these laws, but it's certainly an uphill battle. It's not an easy thing to get around at all. It's very much a nuclear option, and one that, frankly, I think we should all collectively, take a bit more seriously. Like, this is a big deal. If they're willing to do it to persecute us, that means they get to like literally do anything, right? Because like there's no limit to the notwithstanding clause. Like they literally, like a government could literally use the notwithstanding clause to try to reinstate slavery if they wanted. That's not a power that I'm comfortable with the government having, even if they don't use it. And the fact that the government seems more and more willing to use it to attack minorities, and in fact, it's pretty unique the way in which the notwithstanding clause is being invoked here, right? Because it's the first time that it's invoked against a minority supposedly for the benefit of that minority. It's the first time that the notwithstanding clause, to my knowledge, is used to take away somebody's right and saying it's in their own best interest. All of the other examples I can think of are still, many of them are still attacking a minority, but usually their argument is that, it's a facially neutral law for the benefit of society that happens to have a discriminatory impact, and they're saying that the state building, the nation building aspect of it is just outweighs the discriminatory impact, and we should just allow it. And still disagree with those, but it's still vastly different as a logic, I think, than saying, like I'm gonna take away your right to life, liberty, and security of the person for your own good. Like there's something really just like something is not like the math isn't mathing.
Yeah. To me, I would love to see a amendment to the notwithstanding clause so that if you're going to invoke it, you have to read from a little card that says, and I'm doing this explicitly to take away this group's human rights. I think if you had that caveat on the end of it, there's a lot of politicians who'd be a little bit more
Uh,
gun shy
I
if
wish I shared your hope. I wish I shared your hope. I don't think that would actually change much. I'm more of the view that if we do have if we're gonna have a notwithstanding clause, at the very least, one of the things that it should be subject to is a supermajority rule. Because if you can't get a wide agreement across all of society, both across conservative and liberal spheres of society, that this is of utmost importance, then what business do you have using the notwithstanding clause in the first place? Like, it's meant to be a nuclear option, and if it's really a nuclear option worthy scenario, then you shouldn't have trouble getting a supermajority.
no. Um, is there anything else that you want people to hear? Is there anything else you want people to know? I mean, we've covered a lot of legal ground today.
Yeah. I mean, I still have a little bit of spiel. I still have a little bit
Yeah,
of spiel. There's
please.
I had two main spiels. Um and well, okay, I guess three main spiels. The first one is just like a very quick reminder, like if they can do this to trans people, like this isn't the end, this is the start of it, right? Like they're gonna come after other people when it's convenient for them, and you should be scared because if they can take something away that's so fundamental as the right to be your own gender, then what can't they do to you? What rights can't they take away? And I can guarantee you that every one of us does something that the UCP doesn't like. Even if you're like the most conservative of conservatives, there's still something about you, one way or another, that Danielle Smith would happily fuck with. And that should scare you. You want to be protected against the government. We all want to be protected against the government, and that, starts by showing up for trans people. That means, showing up for the first minorities that are being attacked in this new cycle of hate, because certainly not the first, certainly not the last, but we're seeing a new cycle, and it's time to show up because you know if our rights are fragile, so are yours. And think about something that you care about. Think about a constitutional right you have that you care about. Do you like driving? Well, they could fuck with your right to drive especially easily. In fact, they already do. Do you want to get arrested without trial the moment did you say something mean against Danielle Smith on social media? Because that's what we're starting to look at, especially with the way that they're approaching bail reform and talking about using the notwithstanding clause. That's at the federal level, but still. So pay attention and show for that. So that's the first thing. The second thing is look at the ways in which those bills will be hurting people that aren't trans. Because, okay, yes, I wish everybody could just, care about trans people because it's important to care about trans people. Fine. But I'm also not delusional. I know that it's not how society works, and a lot of people won't care enough to actually show up. Like you might care, but they're not enough to actually like do anything about it. And so look at those bills and look at the ways in which it's harming other people. Because the first thing I notice is first, There's a whole kind of surveillance mechanism built into the sports bill that's very scary about, all of these, reporting requirements for anything relating to sport to the government. First of all, that's pretty scary in the first place. But a lot worse, uh, there's protection from civil liability for anybody who thinks in good faith that they're enforcing the policies or the law. That means that you're giving a big old stamp of approval, enabling a lot of people bullying any female athlete, trans or not, that they see as insufficiently feminine, that they see as too good at the sport, so that they just don't like. Um, and they'll say, well, I'm just, verifying their gender for the purposes of the law, and therefore nothing can be done about it. I'm perfectly immune from anything in this regard. And given, first of all, the level of harassment we've seen towards Black women, towards racialized women like Iman Khalif in the Olympics, that should scare you. What should also scare you is that we've seen cases where 9-year-olds were being harassed, where people, got groped, and the whole specter of kind of like quote unquote genital verification. Uh, if people believe in good faith, they're applying the law, then they're immune. And do you really want to give that power to, first of all of the mean teenagers on your kid's team the moment they decided they don't like your kid anymore? And also the older creepy coach. Yeah, sure, not all coaches are creepy, but you're gonna have some creepy coach at some point somewhere, and that coach is gonna benefit from that civil liability immunity. So, do you feel okay with that? Do you feel okay with a law that gives carte blanche of people to sexually harass children and teenagers in the name of enforcing Danielle Smith's new law? Personally, I don't. The other thing is education. First of all, this is a don't say gay trans bill, right? Um, among many things, but one thing it does is makes it, prohibitively difficult to talk about, queer and trans people existing. The same shit that we were saying was just like insane in Florida and Texas not too long ago. So that was the first thing. But that's still not going to be enough for a lot of people. So this is essentially killing sexual education in the province. Yes, technically you can get, your materials approved by the minister, and you can, tell parents 30 days ahead of time of any plan that you have, every single time, and you have to, make alternative accommodations for students whose parents don't consent. You could, I guess, get through all that. But realistically, the reality is most teachers won't. The overwhelming majority of teachers won't. And also, they'll still be limited to approved material. And what is going to be the quality of that approved material with this government that seems to, be ultra conservative and really hate, sexual education? The reality is, kids aren't going to be learning about consent. They're not going to be learning about describing their own anatomy. They're not going to be learning about, what sex even is. And what that's going to do is that for kids who are being sexually abused, for kids who are facing sexual violence, they're not going to have the tools to communicate their experiences, to report their experiences. And they're going to be a lot more vulnerable to continued abuse. And essentially we're making all children across the province more vulnerable to sexual violence. This is just an immense amount of harm that's going to come by them. And that's before we even get into the question of like how many teenage pregnancies more are going to happen, how many more STIs are going to happen. But there's one thing that supposedly we all care about. It's stopping sexual violence towards kids. Supposedly we all care about that. Some people seem to come to the view that some people who say they care about it don't actually, especially given the number of people who call drag queens pedophiles and then end up being arrested for child pornography. But, you know, assuming we can all agree that that's something we want to eliminate, then why the hell are we getting legislation that is delivering children into the hands of abusers? We shouldn't want that, and we should all be really fucking pissed at the government for this shit. So, stepping off my soapbox, that was my last soapbox moment.
I want to thank you so much for the soapbox moments. I want to thank you for being willing to go through some of the legal nuances here, because I think that one of the I had a conversation just recently with another associate law professor, Lorian Hardcastle, and in it I posed the question: should we be having professional colleges for politicians? Because I think at the end of the day, the roots of so many of these problems is politicians who gleefully act in bad faith in order to scare people, because and to make them angry, because angry, scared people will give you money. Angry, scared people will show up for you. And it's wild to me that there is no mechanism by which we can say to an elected official, please stop lying. Please stop it. You're lying. Stop it. There's no mechanism. They just get to do it. And that's wild.
In I don't know if you've seen, I think it's in Wales, they're trying to, there is a Welsh lawmaker that's trying to make it illegal for politicians to lie. Um, and you know what? That's not the worst idea.
I mean, if
Obviously, it
we're
would
going to
have
have
to,
the notwithstanding clause, let's have that too.
yeah. Like, I think there's a need to have a few changes in politics. The level of just ridiculousness that goes on in the chambers. I'm starting to think maybe we need to rethink the cameras. Like, I'm big on having cameras in the legislature. I think it's so important to have that transparency, but like it has made sessions completely useless because all they're doing is trying to show off, trying to peacock, trying to show whatever off to their base, and instead of actually having the discussions that need to be had. So we need to do something about that. Probably not remove the cameras, but something. Maybe actually have a harder hand in terms of like maintaining decorum and getting people to answer the damn questions. People need to answer the questions. Like, can they? Maybe that needs to be the rule. If you if you're not answering the question, we just cut your mic.
I'd be up for that. And I agree with you 100%, because the question period piece has become pure theater, and it's heartbreaking for somebody, well, I think for anybody who has any sort of respect or uh I mean, I'm going to get cheesy, but like I have a great love for democracy. I have a great love for the places where democracy happens. And to see the legislature cheapened by these people who think that they're being clever with their bad theater. It's just like, if you were putting on a good show, at least maybe I could get behind it, but your jokes aren't funny and you deliver the lines badly. So
Uh,
this isn't even like,
yeah.
this isn't even community theater. This
Maybe
is
we can give them like a small like 5 minute to be sassy, and then they can actually do a real like their job for real for the rest of the time.
legislature open mic night every Tuesday.
Yeah.
Um, Florence, thank you so much for taking the time and having this
Sure.
conversation. I'm so glad that we finally were able to make this happen. So just thank you, thank you, thank you.
Yeah. All right. Well, have a great evening.
Thank you. And that's it for another episode of The Breakdown. As always, if you appreciate the kind of content that we're trying to produce here, we would love nothing more than if you thought about signing up to be one of our Patreon sponsors at www.patreon.com/thebreakdownab, where for just the price of a fancy cup of coffee a month, you can help us continue to produce this kind of content. Whether you're listening to the audio version of the podcast, in which case, maybe leave a review and a rating, or whether you're watching it on one of our streaming platforms, we want to say a big thank you to everybody who is part of the Breakdowns audience. And as always, take care of each other and keep the conversation going.